All right, so the time I have by my computer is 12:45. Waiting for a few more folks to drift in. And I did see Judge Flood previously, a few minutes ago. There she is. All right, welcome back, everyone. We just are returning from our lunch break. Time is 12:45. We're ready to begin with the cross-examination of the witness. Ms. Rasnick, are you ready to go?
This video is so crazy. So this judge is under fire because of how she treated her staff. She was very rude. She would yell, cuss, whatever. You'll see the hearing. But it's so crazy. I've like and the questions that they ask her are hard ones, and she has the worst attitude throughout the entire hearing. And it's like, girlfriend, I would switch that around and show that I'm nice and not just power headed. But you'll see.
I am.
All right, Ms. Bremner, are you ready to go?
I am. Thank you, Your Honor.
All right, please proceed, Ms. Rasnick.
Good afternoon, Judge Flood. Can you hear me okay?
Yes.
Okay. You have admitted that you verbally admonished your staff for not following instructions. Is that right?
I have admitted to what's in the stipulation.
Okay. Does the
And that's all she really says to her answer to every question is, that's what I agreed to in the stipulation. I agreed to those in the stipulation, with an attitude. And it's like, okay, yeah, you did agree to those in the stipulation, but you're still gonna be in the hot seat and ask these questions. And it's probably good for you to be honest and not rude and be like, read the stipulation. I said it was true. So that's just how her whole attitude throughout the entire hearing. And it's frustrating because it's like, girl, chill.
stipulation include verbally admonishing your staff for not following instructions?
I'll object unless it's shown to the judge. If we're referring to a document, I think it should be shown to her.
Overruled, at least at this point. We'll see what the answer is.
All I really gotta say is that I love this judge that is doing this hearing right now on this other judge, because on a lot of the objections, he overrules, and it's amazing to watch. It's just because she's such a biatch throughout the whole hearing, and then if she's a judge and treating her staff bad, I mean, come on, there's no need for that. You're already in a powerful position.
I believe that it contains some language to that effect from my memory.
Right. Let's take a look at it. Judge Flood, do you see the document that's being shared?
Yes.
Okay, I'm going to scroll up to the top. Do you read that it says stipulation to facts and code violations? Did I read that correctly?
I see it.
Okay, did I read it correctly?
I didn't hear everything that you said, but I see it. Yes. So you kind of faded. So
Do you see that it says stipulation to facts and code violations?
in my yes, I see it.
Thank you. Just going to scroll all the way down. This looks like an Adobe sign or a DocuSign. Do you remember electronically signing this document on October 21st, 2024?
Yes.
Okay. Did you also verbally admonish your staff for making mistakes?
I believe the document speaks for itself, ma'am.
So you agreed in this document that you verbally admonished your staff for making mistakes?
I believe the document reads, at times responded verbally admonished staff for not following her instructions for making mistakes.
Thank you. You also agreed that you communicate them in a manner that was pointed and harsh, correct?
It says, though responded, rarely raised her voice her communication could be pointed and harsh.
So you agreed that you did communicate with your staff in a way that was pointed and harsh.
Objection. The document speaks for itself. Asked and answered. Argumentative.
Overruled.
I'd ask the court to direct the witness to answer.
Could you repeat your question?
You admitted that you did communicate with your staff in a manner that was pointed and harsh, correct?
I agreed that it could be.
When you agreed that it could be, did you also agree that it sometimes was?
I believe that it could be.
Okay. You agreed that you could be condescending to your staff, correct?
I object again unless the document is used in reference, Your Honor.
Overruled.
It says when that happened, when that did happen, respondent could be condescending, which made some staff feel humiliated, embarrassed, and anxious.
I'd ask the answer be stricken as non-responsive and the court direct the witness to answer the question.
I take exception, Your Honor.
I'm denying the motion to strike the answer, but the witness needs to listen closely to the question and answer the questions that's asked.
I'm going to try that again, Judge Flood. So by signing this stipulation, you admitted that you could be condescending to your staff.
Objection is asked and answered. Argumentative.
Overruled.
The stipulation states that.
But you don't believe that's really true.
The stipulation is what I agreed to.
I'm asking you a different question. Do you believe that's really true?
I'm not understanding your question.
What part of it don't you understand?
You're asking, what are you asking? Maybe you should restate the question.
Right? You said you agreed when that did not happen, respondent could be condescending, correct?
Say that again. I'm sorry. I'm not
Okay.
understanding if you're asking me if I said something or if the document said something.
Okay. Do you agree that the document says when that did not happen, respondent could be condescending?
Yes, I agree. The document says that. Yes, we have that in front of us. Yes.
Okay. Do you agree that it's true that you could be condescending to your staff?
Same objection, same basis.
Overruled.
See what I mean? The judge keeps overruling everything. And I feel like it's because he wants to hold her accountable and be honest and real. Because all of her answers are what's in the stipulation. I agreed to that, so what does it say? Yeah, I agreed to it, so it must be true, right? Like, rude. So I feel like the judge is like just overruling it and saying, you know, go ahead, fix your attitude, answer it right.
Do I believe that this is true? The statement or the stipulation?
I'm going to ask that that be stricken as non-responsive and the witness instructed to answer.
I would take exception.
Yeah, I'm not striking the answer, but clarify the question. Ask it one more time, please.
Okay. Is it true that you could be condescending to your staff?
I believe that that is the opinion of some staff, and as a way to accept responsibility, this is what is in the stipulation.
Okay. Do you agree that the stipulation says you made some staff members feel humiliated, embarrassed, and anxious?
Same objection, same basis.
Overruled.
Can you repeat the question?
Do you agree that the stipulation said you made some staff members feel humiliated, embarrassed, and anxious?
The stipulation says that.
Do you agree that you did make some staff members feel humiliated, embarrassed, and anxious?
That's what I have been told, and that's what I have heard.
So from my understanding, yes, she did agree to the stipulations. She said they were true, whatever. But anybody could agree and sign a document, right? So I feel like the questions are, do you feel in your mind, in your heart, that these statements are true, that you really treated your staff wrong, you know? And she won't answer it. All she says is, if it's in the stipulation, it must be true. Well, I agreed to the stipulation, so it must be true. And I think the judge keeps overruling all of the objections because he wants her to just be real. Like, this is your time to be honest. Like, yes, I was mean. Yes, I was in a bad mood. Yes, I was rude. You know? Apart from what's in the stipulation, it doesn't matter. But it's what you believe in your heart and your mind. And I feel like she's just being so vague and nasty and mean about it. And I feel like the judge is just going to be like, be honest, or otherwise I'm going to overrule every objection.
So
Okay.
I can't control another person's feelings, and I don't know outside of what's been told to me how a person is feeling.
Do you agree that the stipulation says some staff believed that you did not clearly communicate your expectations of them?
Yes, that is what the stipulation says.
Is it true that you sometimes didn't clearly communicate your expectations of them?
I'm sorry, can you repeat the question?
Is it true that you sometimes didn't clearly communicate your expectations of them?
From the information that I have, yes, sometimes because there was clarifications being asked. So yeah, there was sometimes where things were not clear.
The stipulation says that you chastised them if they didn't understand what you wanted. Do you agree that's what the stipulation says?
Yes, that is what the stipulation says.
Is it true that you chastised staff when they didn't understand what you wanted?
That is what was described to me.
Is it true?
Objection is asked and answered.
Ruled.
I need for you to repeat your question.
Is it true?
Under the definition and what was described to me and how people felt, sometimes.
The stipulation says you denied having given unclear instructions. Is that correct?
Yes. Yes.
Did you deny having given unclear instructions?
Yes, that's what the stipulation says.
But did you deny having given unclear instructions?
Yes.
The stipulation says that staff often heard you to respond, "That's not what I said," or "I didn't say that," in response to their concerns. Do you agree that that's what it says?
That's what the stipulation says.
And do you agree that you would respond, "That's not what I said," in response to staff concerns?
Yes.
And how about "I didn't say that"? Do you agree that you would respond, "I didn't say that," in response to staff concerns?
Yes.
The stipulation says that some of your staff became increasingly wary of engaging with you. Do you agree that it says that?
Yes, that's what the stipulation says.
And do you agree that's what happened? That some of your staff became wary of engaging with you?
Yes, that's what some staff has said.
You were a practicing attorney before you were elected a judge, is that correct?
Yes.
Do you agree that it's the job of a practicing attorney to push back on the judge in court?
Objection, form of the question, and it's vague.
Overruled, given the use of that term throughout the direct examination.
No. I believe it's the job of a good attorney, a defense attorney, to advocate for their client. There's a difference in pushback and advocation.
Do you agree that it's an attorney's job to disagree with the court?
Same objection.
Yeah,
I don't know that.
hang
I'm
on, I'm
sorry.
going to sustain that objection. I'm not sure what that means.
You testified you are a graduate of the Washington Law Institute. Is that right?
The Washington State Leadership Institute.
Okay, thank you for the clarification. You also attended Judicial College?
I attended Judicial College in Reno, Nevada, and the general jurisdiction, and I attended Judicial College for the state as well.
And after the CJC contacted you about the complaints, you worked with a coach, is that right?
I worked with her to do some work with me and the court.
And you chose to work with Ms. Lavery, is that right?
Everyone that I work with, I have chosen to do so.
Is that a yes? You did choose to work with Ms. Lavery?
Yes.
And when you chose to work with Ms. Lavery, that was after the CJC had contacted you about the complaints, is that right?
No.
Your testimony is that you worked with Ms. Lavery before you heard from the CJC about the complaints?
I talked and made arrangements with Ms. Lavery before I heard from you.
And did you continue to work with Ms. Lavery after you heard from the CJC about the complaints? And you testified that you've recently been through empathy training, is that correct?
The training that was mentioned by the court administrator was a resiliency summit with a focus on empathy through a simulation. So it per se, if you want to say that it's an empathy training, then you could say that. But it was a focus on individuals in the system having empathy for defendants and incarcerated individuals and those that have had contacts with the system. So that simulation was based on the role play of being put in jail, having $20 to survive on a month. What do? Do you take a UA for your probation, or do you buy food for your kids? So that was a simulation in empathy for the defendants.
Thank you. Dawn Williams was the court administrator at Bremerton when you took the bench in 2022, is that right?
Yes.
And Dawn had a lot of institutional knowledge as the court administrator, is that right?
Object, lack of foundation.
Overruled.
Can you ask your question again?
Dawn had a lot of institutional knowledge as the court administrator, is that right?
Institutional knowledge. Is your question about Bremerton? Is it about a court administrator? Or
Let me come at this a different way. Dawn Williams, is it fair to say she had been the court administrator for 11 years?
I don't know that for sure.
Did you have any understanding of how long she had been the court administrator when you
No.
took the bench?
I did not.
Did you later develop an understanding of how long she had been the court administrator?
I I understood that there had been a previous court administrator to her that she replaced, but I do not know. I did not know the time frame.
Did you later come to learn that Ms. Williams had been the court administrator for 11 years?
Objection, asked and answered.
Apologies, I couldn't get my clicker. I'm gonna permit the question one more time. Overruled.
What was the question?
Did you later come to learn that Ms. Williams had been the court administrator for 11 years?
I again, I do not know the exact time.
Did you benefit from Ms. Williams' knowledge as the court administrator?
On the things that she shared with me.
I was going to object. It seems facts, not in evidence, because she doesn't know her experience. But the answer, go ahead. I'd say the judge should just go ahead and answer to expedite this.
Yeah, okay. Overruled the objections. Overruled. Go ahead and answer.
On the things that she shared with me.
And in the stipulation, you admitted that Ms. Williams experienced you as constantly critical of her. Is that right?
I don't know if that's something specific or not, but what's in the stipulation is what I admitted to. I'm not understanding why the things that are in the stipulation are what I stipulated to and admitted to, and I'm accepting responsibility for today.
Do you agree that you were at times constantly critical of Ms. Williams?
And I object. She stipulated this. It's in the record. It's before the commission. ER 403, waste of time.
I'm going to overrule based upon the direct testimony. Overruled.
Can you repeat your question?
Do you agree that you were at times constantly critical of Ms. Williams?
Are you? I would ask that if that's what the stipulation says, for me to be able to see it, because I don't remember everything that is in that stipulation.
I'm not asking you about the stipulation, Judge Flood. I'm asking you if you agree that you were at times constantly critical of Ms. Williams.
Your Honor, I do have to object. If she's referring to a document, it should be shown to the witness. The witness has asked for the document, and she appears to be quoting from it. So that's my objection.
Okay, overruled. Question is not related to a document.
I believe I hear you saying two things, so I'm going to try to answer your question. You said at times, constantly. At times and constantly does not go together. So my response would be, at times I feel and have been informed and am accepting responsibility that Dawn felt that I was critical of her.
You also stipulated that Ms. Williams believed that nothing she could do would satisfy your expectations. Is that right?
I believe that if that's contained in the stipulation, then yes.
Okay. Do you agree that it was difficult for Ms. Williams to satisfy your expectations?
I don't know. I don't think I can answer that question. I believe she may have felt that way, and I can acknowledge that she felt that. I can't do any more than that.
Judge Flood, you reached out to Courts Helping Courts in September 2022. Is that right?
Yes.
And you asked Trish Kinlow for help at your court. Is that right?
Yes.
And you told Ms. Kinlow that you thought the trouble at the court was because of racism. Is that right?
Not specifically in those terms.
How did you put it when you told Ms. Kinlow that?
I believe the conversation was, I was concerned because of an incident that happened with an employee calling me by my first name, and that I'm experiencing micro and macroaggressions in the behavior of the staff, and that I was told to reach out to her, that there could possibly be some support that she may know about, and to ask her for assistance. She told me that I should definitely talk to HR and send an email to Courts Helping Courts. And then I don't know if we scheduled a follow-up after that.
Okay, I'm going to ask another question. All right, I'm mindful of our time. I don't mean to cut you off, but I'm very mindful of our time.
Your Honor, I object. She should be allowed to finish her answer.
I'm going to permit the question, another question to be asked.
Okay. Who suggested you reach out to Courts Helping Courts?
A judge friend.
Who was the judge friend?
I believe it was Judge Chess.
You mentioned that you had told Trish Kinlow that you were experiencing microaggressions and macroaggressions. Is that correct? Did I get that right?
Yes.
And microaggressions and macroaggressions are racism. Is that right?
They're forms of biases.
Are they forms
that
of...
are...
I apologize. Go ahead.
So to answer your question, it's forms of that fall in that category of inequity, racism, biases, implicit biases, explicit biases. Overall.
This is what you told Ms. Kinlow.
It was in conversation, so it was a general, fast conversation. It wasn't getting into any details as to who I was saying that it was from. I said I was experiencing it at the court.
Okay. And was it your impression that Ms. Kinlow understood you to mean you were experiencing racism at the court?
I don't know what Ms. Kinlow took from that other than me asking for help.
Okay. And Ms. Kinlow is a Black woman, is that right?
Yes.
When Ms. Kinlow and Jennifer Johnson came over to Bremerton Municipal Court to help, you welcomed them, is that right?
Yes.
You were really happy to see them, is that right?
I was relieved.
You were relieved to see them. Did I hear you correctly?
Yes.
Do you remember saying to them that they were your guardian angels?
I was referring to the program of Court Helping Courts as they were there representing Court Helping Courts. So yes,
Okay.
in that context. Context.
And Ms. Johnson is Black and Mexicana. Is that right?
That's what you have in the paperwork. She told me she was Puerto Rican.
Okay. Do you have any reason to think that she's not Black and Mexicana?
She told me she was Puerto Rican.
I see. Do you believe her that she's Black and Mexicana?
I believe what she told me. So I believe that in the Latin, American, Mexican American, when you're talking different cultures and countries, some people who are of mixed descent like that refer to themselves at times as Puerto Rican. Some of them refer to themselves as time as Black and Mexicana as you're describing here. But what I'm saying is she told me she was Puerto Rican.
Thank you. As the judge at Bremerton Municipal Court, you get to decide whom to hire as court administrator. Is that right?
Yes.
And you decided to hire Jennifer Johnson as court administrator. Is that right?
Based on the recommendations from the hiring panel. I put together a hiring panel for the court administrator's position after Dawn left to replace her. I hadn't made any decisions prior to that. And in putting together that hiring panel, both Trish Kinlow and Jennifer Johnson agreed to be a part of that hiring panel. So Jennifer Johnson was actually a part of the hiring panel. She then asked Miss Gale, can't remember what court she's from, to replace her on the hiring panel. After applications began to come in, she then emailed and said that she was going to apply and asked Gail to replace her on the hiring committee.
But the decision to hire Jennifer Johnson as court administrator was yours in the end, correct?
I took the advice of the hiring panel. My ultimate being the one that signed the letter, I was the only one that could sign the letter. I was the only one who was on staff at the city. So my hiring panel made a recommendation and I adopted that recommendation.
Thank you. You could have contacted Judge Leone as a reference check for Jennifer Johnson, right?
I could not contact Judge Leon because Jennifer Johnson did not give me her telephone number. And she told me that Judge Leon was on bereavement leave and not available. So I could not contact her.
Your testimony is that Jennifer Johnson prevented you from contacting Judge Leon?
My testimony is that I did not get the telephone number for Judge Leon from Jennifer, that Jennifer Johnson told me that Judge Leon was on bereavement leave. That is my testimony. So I did not get a chance to talk to Judge Leon before I hired Jennifer Johnson.
You didn't take any steps to try to locate Judge Leon's contact information?
I did not want to, if being respectful that she was on bereavement leave, I did not want to impose during that time.
You saw the former probation officer, Ian Cohen, testify earlier this week. Do you remember that?
Yes.
Do you remember seeing Mr. Cohen break into tears a couple of times while he was testifying?
I saw him wiping his face.
You just sort of smiled a little bit. Why did you smile when I asked you about Mr. Cohen breaking into tears?
Because your description is breaking into tears. I saw him wiping his face. So that's a difference of your opinion is that he broke into tears. My opinion is that I saw him wiping his face. I wasn't watching his every move. So descriptions are very important. And you're, of course, the prosecutor. So your description is one of a prosecutor's.
Thank you. Do you agree that the stipulation states that Mr. Cohen experienced you as constantly critical of him?
Objection.
I know the
Like a foundation speculation, she's asking what he thought and what he perceived. And the stipulation speaks for itself and should be shown to the witness in any event if it's being used.
Well, I'm going to sustain the objection unless the question is, does she, it's to me a fair question whether she remembers what's in the stipulation. But if you're going to ask her if it's in the stipulation, that to me needs to, I'm going to sustain the objection with respect to that being an aspect of the question. I'm not sure I understand the question.
Okay. I will try it again. Judge Flood, do you recall that the stipulation states Mr. Cohen experienced you as constantly critical of him?
Same objection, same basis.
That one's overruled.
Can you please ask your question again?
Judge Flood, do you recall that the stipulation states Mr. Cohen experienced you as constantly critical of him?
I do not recall specifically what the stipulation states as to Mr.
Okay. Let's take a look at it. Are you able to see the document?
Yes.
Okay. I would direct your attention to the first sentence of paragraph F. Does that sentence say that Mr. Cohen experienced you as constantly critical of him?
Objection unless it's read in its entirety and context.
Overruled.
So from my read of it, the probation officer, Mr. Cohen, also experienced respondent as constantly critical of him and believed that nothing he could do would satisfy respondent's expectations. Yes, that's what I agree to, and that is the full sentence.
Okay. Were you critical of Mr. Cohen?
In the sense of bringing things to his attention that needed to be corrected, that is termed as critical, yes.
And did he have difficulty meeting your expectations?
From my understanding, yes.
Was your experience that he had difficulty meeting your expectations?
In some conversations with Mr. Cohen, he would say, Judge, I'm trying to not do things the way that Judge Doctor did them, but trying to learn your new way of doing things. So with that leads me to believe and admit to in these proceedings that he had difficulty. Because again, he said he had done things for so long, Judge Doctor's way, and the way that things go, that he had difficulty making changes.
All right. I'm looking a little bit farther down in that same paragraph F now at the beginning of the next page. This sentence says that Mr. Cohen felt humiliated by your treatment. Do you see that?
Yes.
You agree that Mr. Cohen felt humiliated by your treatment.
Objection, speculation, and what he felt, or that she can agree to it.
Overruled to the question, to the narrow question, overruled.
What was the question?
You agree that Mr. Cohen felt humiliated by your treatment. Is that correct?
Again, the stipulation language is based on what I have been told as to how he felt. And it states that Mr. Cohen felt humiliated. So that is what I am agreeing that he has said that he felt. So yes, but I can't determine another person's feelings.
Thank you, Judge Flood.
Testify and say, I know only that person has their feelings.
Thank you, Judge Flood. I'm going to move on now. You hired Serena Daigle to work for Bremerton Municipal Court. Is that right?
Yes. Serena came to us through Court Helping Courts as well.
Right. And then you hired her to work for the court. Is that right?
Yes. Serena indicated that she, through text messages, she wanted to be my sidekick. She had hoped to be the court administrator.
Okay. And you agreed that she would be a good fit as an employee of the court, so you hired her.
Actually, I first interviewed Serena for a court administrative position. The panel said that she would not be a good fit.
So you hired her for a different position.
I then listed the position of senior legal technician, and Jennifer Johnson wanted to bring her on. And so Jennifer Johnson wanted to work with Serena because she said she had worked with Serena at Des Moines. My choice for that senior legal technician was different from Jennifer's.
But you agreed to hire Serena.
Yes, because the court administrator said that she had the experience and could work with her.
Right. You agreed in the stipulation that you spoke to Serena Daigle in a manner that she felt was impatient and discourteous. Is that right?
I believe the stipulation says on one occasion when Ms. Daigle was filling in the courtroom and Ms. Daigle asked the respondent to clarify a ruling in court, respondent spoke in a manner Ms. Daigle felt was impatient and discourteous.
Do you agree that you spoke to her in a way that was impatient and discourteous?
Objection, asked and answered.
Overruled.
I believe that she felt the response was discourteous and impatient.
You admitted raising your voice and yelling across the clerk office at Amber Dodge on that incident that you talked about during your direct exam. Is that right?
No.
You did not admit that you raised your voice and yelled across the clerk's office at Amber Dodge?
I object, it's asked and answered.
Sustained.
Did you stipulate that you shouted at Amber Dodge across the clerk's office?
I believe there's language in the stipulation. If you want to refer to that, you should bring it up.
All right. I'm looking at paragraph NA, which starts on the bottom of page 4. I'm looking at this sentence. So you admitted that in a raised voice, you shouted at Ms. Dodge, "I have been waiting in the Zoom waiting room for over 10 minutes. Will someone please let me in?" Is that correct?
Objection unless it's the rule of completeness, the full sentence, paragraph, context isn't being shown or referred to.
Well, the entire paragraph is being shown. What? What aspect of the paragraph is not complete with respect to the sentence that was read?
Well, anytime, Your Honor, that it's not read for the full sentence, just part, I think is a proper objection.
Did you
Um,
read the full? I'm sorry to interrupt. Did you read the full sentence, Ms. Rasnick?
I did not, but I certainly can. But the full sentence is visible to everyone.
I that's my objection, Your Honor.
Okay, read the full sentence, please.
Sure, I'll rephrase the question. Judge Flood, did you admit in the stipulation, standing in the doorway at the other end of the room, respondent in a raised voice shouted at Ms. Dodge, "I have been waiting in the Zoom waiting room for over 10 minutes. Will someone please let me in?"
Same objection. There's, unless I'm not seeing this correctly, it looks like there's a dash before the standing and there's further language before that.
Overruled. That dash looks like a footnote.
Like a what, Your Honor?
To me, it looks like a footnote. Objection's overruled.
Oh, all right, thank you.
So what the stipulation states is raised voice and shouted, not yelled. And I was standing in the doorway. I was not in the room.
Sorry, Your Honor, I'm not sure what has happened. I don't see Judge Flood on camera.
Your Honor, she's taking a second and composing herself.
And just for the record, she appeared to be very upset and turned off her camera and said something like, "I need a moment," or something like that.
All right, it appears that Judge Flood is back with us. Ms. Rasnick.
All right. Judge Flood, earlier today, I believe it was today, you testified that you were handling a matter on the record in Bremerton Municipal Court this past Monday, October 21st, from 8 a.m. until about 8:27 a.m. Is that right?
Wasn't it Wednesday?
No, that would have been Monday, October 21st.
I was on the record in my court for our video and custody calendar on Monday at 8 o'clock. And I gave the reasons why.
You testified earlier that you were handling an order for a therapeutic court participant. I just want to make sure I'm tracking that. Is that correct?
When I came on the record, I asked the jail to please bring Mr. Sampson in because he was not there and he is the therapeutic court participant who I wanted to have heard.
Thank you. But a court commissioner was available who could have signed that order regarding Mr. Sampson, right?
Sims facts, objection.
Overruled.
A court commissioner could not have handled the order the way that it needed to be handled, as all the matters dealing with our therapeutic court committee and participants, there's additional details how the orders have been handled. And so she did not have that information, and I did not have all of that information until that morning.
And when you logged on to the hearing about 8:40, you said you had not had an opportunity to review the proposed stipulation. Is that right?
Objection, this is all beyond the scope, Your Honor, and counsel's testifying as to the time.
Overruled.
I said that the stipulation, as I recall, had not come in to me before 8 o'clock. So the stipulation came in from my review of my emails after and while I was logging in to the proceedings that was set to start at 8:30.